Hello, this is Irwin Ironstone. This is Justice in America. And along with that, justice is what you can afford and not necessarily equal for all. The session today will deal with an article that was written by Erwin Chemerinsky. And say, who is Erwin Chemerinsky? He's the Dean of Berkeley Law School and is recognized as one of the foremost constitutional scholars in the country. The article deals with the myth of plain meaning. And I've both quoted and added to things that were in an article that was published in an email sent by the American Bar Association. Over recent years, the U.S. Supreme Court increasingly has embraced interpreting statutes based entirely on plain meaning of the words and forgetting consideration of legislative history. Justice Scalia was a champion of this when he was on the court, but recently Justice Kagan, Elena Kagan, remarked on his influence when she declared, "We're all textualists now." A textualist is a justice who relies on the words in the statute, quote, plain meaning, even though there is effectively no plain meaning. It's interpreted by the justices when they don't want to give their reasons for ruling the way they did. The problem with this approach is that the cases come to the Supreme Court involving statutory construction rarely involve laws where the language has a clear, plain meaning. Instead, the court engages in a fiction. It quotes the ambiguous language, declares that there is plain meaning, and then comes to what it wants the desired conclusion to be. In other words, it doesn't use any history from the legislature to determine what the meaning of the statute is. It's clear that the Fair Debt Collection Procedures Act was drafted because consumers were being screwed by people who were abusing them when they tried to collect debt. In other words, the Supreme Court makes up a story and ensures that the story allows them to rule in a case where the law is ambiguous. And when I say the law is ambiguous, I'm really saying the English language itself is not exact and frequently requires modifications and clarification. Two cases from last term, and that would be the 2017 terms, involve the Fair Debt Collections Practices Act, or FDCpA, and these two cases illustrate that point. Let's look at the Fair Debt Collections Practices Act. And one of the cases is Midland Funding versus Johnson. Early last spring, the court decided a case involving interpretation of the Fair Debt Collections Act. It was decided May 15th, 2017. Case was decided by 8 justices because that's all that were on the court. Justice Scalia had died and the new justice was not yet appointed. Case questions whether creditors violated the Fair Debt Collections Act when they file a proof of claim in bankruptcy court, knowing the case questions whether creditors violated the Fair Debt Collections Practice Act when they file a proof of claim in bankruptcy court, knowing that it is barred by the statute of limitations. Johnson filed for bankruptcy under Chapter 13. Chapter 13 is where the debtor has to pay back creditors a certain amount each period of time, and that's handled by a trustee who establishes what the debts are and what the amount to be paid back are. In this case, Midland Funding, the owner of a debt, filed a proof of claim in the bankruptcy case saying that Johnson owed Midland credit card debt. However, the last time that any charge appeared on Johnson's Midland account was more than 10 years ago. The relevant statute of limitations under Alabama, the law where the action occurred, is 6 years. One might ask, why are they filing a notice of claim or proof of claim when the statute of limitations has effectively passed? Statute of limitations says this is no longer a good or valid claim. And the Fair Debt Collection Practices Act forbids a debt collector from asserting any false, deceptive, misleading representation or using any unfair or unconscious means to collect or attempt to collect a debt. The question is, why are they filing this claim when it's 10 years old and the statute of limitations only allows for 6 years to say this debt can no longer be collected? The Supreme Court, in a 5-3 decision, reversed the decision of the 11th Circuit Court of Appeals and held that the filing of a proof of claim that is obviously time-barred does not violate the Act. Justice Breyer wrote for the court, joined by Justice Roberts, Chief Judge, Justice Kennedy, Justice Thomas, and Justice Alito. And they basically said it was okay to file a claim even though it couldn't be collected. If they tried to do it, there's a defense, but the defense has to be asserted by the person who the claim is against. Most people don't show up in court, in which case the creditor gets a default judgment and can go after the debtor. Okay, Justice Sonia Sotomayor, formerly of New York, as are several of the justices, wrote a strong dissent joined by Justice Ginsburg and Justice Kagan. The court came to its conclusion by asserting that words of the statute clearly resolved the case. Justice Breyer used to challenge Justice Scalia and said that plain meaning shouldn't be used without looking at other factors. In this case, he used plain meaning himself. And he says, we conclude that Midland Funding filing of a proof of claim that on its face indicates that the limitations period has run does not fall within the scope of the 5 relevant words of the Fair Debt Collections Practice Act. In other words, what he's saying is, as long as they say it's obsolete, or that means that it's okay for them to file this and waste the court's time, the trustees' time, and everyone else's time. Filing a claim knowing that it is time barred seems unfair and unconscionable, Justice Sotomayor said in her dissent. Professional debt collectors have built a business out of buying stale debt, filing claims in bankruptcy court to collect it, and hoping that no one will notice that the debt is too old to be enforced by the courts. This practice is both unfair and unconscionable. One must wonder why they're doing this. It appears that those who file these claims meant to collect a debt where the statute of limitations had run. It appears that those who file these proof of claims do so to collect a debt where the statute of limitations has run or time to collect has expired. Why would they do this? Very simple. Many bankruptcy trustees are overworked and don't find the claims that have expired. Thus, the old debts become part of the bankruptcy plan. A new billion-dollar industry sprung up, buying debt for pennies on the dollar. The creditor then files an action in state court or in bankruptcy court if the debtor files for bankruptcy, hoping that nobody will object. In other words, they're doing this false and unconscionable act, and the Supreme Court said, oh, that's okay. Justice Sotomayor explains that companies file claims in state courts and in bankruptcy courts and in other courts, basically any court they can, hoping there is a default judgment and they can get the debtor to make one payment. And the reason for the one payment is once you make one payment, it validates the old debt and it becomes collectible. Their hopes in these cases is that consumers will fail either to invoke the statute of limitations or to respond at all. In most states, the statute of limitations is an affirmative defense, meaning that a consumer must appear in court and raise it in order to dismiss the suit. If a consumer is too busy or doesn't think much of it or doesn't know that they have to appear in court, effectively the creditor gets a judgment from a court even though the statute of limitations has expired. And the rule for the statute of limitations is to protect consumers against just this practice. And yet, Supreme Court says it's not unfair, it's not unconscionable, because it's a billion-dollar industry. Money runs the world. Consumers do fail to defend themselves in court. In fact, according to the Federal Trade Commission, over 90% fail to appear in court at all. The result is that debt buyers have won billions of dollars in default judgments simply by filing suit and betting that consumers will lack the resources to respond. Consumer may not want to go to court because it means that they have to take a day off to go, and they can't afford not to get paid. Again, if plain language provides any answer, it is that the creditors are engaged in a practice that is unfair and unconscionable, but the court comes to the opposite decision. I was wondering what happens if it's sent to the wrong address, because consumers who are under stress may not stay in the same apartment or house, and they never get the notice, and yet this trial court continues and grants a judgment on a debt. Justice Sotomayor says that a debt collector that knowingly files suit in court to collect a time-barred debt violates the FDCpA, the Fair Debt Collections Act. When they're stymied in state courts, the debt buyers have now turned to a new forum, bankruptcy courts. They have filed thousands of actions to try to collect old debts or to get default judgments. They're paying pennies on the dollar, especially the older the debt is, the less they pay for it. So they may pay 50 cents for something that's worth $100, hoping that they can get a judgment against a consumer. Does not take a sophisticated attorney to understand why the practice I have described in the opinion is unfair. This is quoting from Justice Sotomayor. Takes only the common sense to conclude that one should not be able to profit on the inadvertent inattention of others. It is said that the law should not be a trap for the unwary. Today's decision sets just such a trap. It appears that the court is functioning like it is crazy, or alternatively like the blind, deaf, mute monkeys who neither see no, hear no, or speak nothing, when they should in fact be saying, this is what Congress did. They passed this act to protect consumers. Why aren't they doing it? The court is giving creditors an advantage and is rewarding them for cheating debtors or bankruptcy trustees who fail to object to stale debts. Bankruptcy trustees have hundreds of cases and they don't always go over all of the papers. In her words of desperation, Justice Sotomayor says, I take comfort only in the knowledge that the court's decision today need not be the last word on the matter. If Congress wants to amend the law to make explicit what in my view is already implicit in the law, it needs only to say so. I respectfully dissent. She's saying, hey guys in Congress, why don't you modify the law so it says explicitly if someone has a statute of limitations, you can't use the statute of limitations, a time past there, to file an action to collect a debt. That should be covered in the Fair Debt Collections Act. That was the first case. The second case is also about the Fair Debt Collections Act, and might say it's even worse. There are no dissents, and the unanimous court once again screws consumers and appears to ignore congressional intent. This determination was written by a new justice, Neil Gorsuch, who used the text of the law to reach a conclusion, and this is called being a textualist. And they use the text of the law and does not consider the legislative intent or the language and arguments that took place before the legislation passed Congress and was signed by the President. And as the first opinion before the court, and again, this is in 2017, the court had to interpret the limits on the Fair Debt Collections Act. The case was Henson versus Santander Consumer USA, and it was decided on June 12, 2017. Justice Gorsuch used Justice Scalia's approach and said that the court should follow the plain meaning of the law, even if Congress doesn't have the capability to write a plain meaning. Certainly in congressional debates, they repeated over and over again, this was meant to protect consumers. In any case, the court properly said that the proper role of the judiciary in that proceeding is to apply, not amend the work of the people's representatives. So you have dumb representatives in the Senate and the House, even though they meant otherwise. The court says, we're going to follow what the law says. We don't care what the meaning or the purpose is. In Henson, the issue was whether the act applies to creditors who would purchase a debt from another creditor. And what happened in this case was that Henson sued Santander, who basically bought car debt and was trying to collect on it, and was trying to collect on it abusively. They called people at night, they harassed them about money that they owed. They threatened criminal prosecution even though they couldn't do anything like that. And it was really harassment at its worst. The facts were straightforward. City finance, which finances autos, loaned money to individuals seeking to buy cars. Some borrowers defaulted on the loans, and Santana Consumer purchased the defaulted loans from City Financial and then tried to collect what was owed. The complaint in the lawsuit alleged that Santana Consumers engaged in abusive conduct that violated the Fair Debt Collection Practices Act. In my opinion, the Fair Debt Collections Act was passed to protect consumers. Everyone knows that, except 9 justices on the Supreme Court. As in this case, the person or group that bought the debt, most likely for a fraction of its face value, was harassing the plaintiff who brought the action, Henson. Congress passed the law to ensure the consumers were not screwed. Here, the Supreme Court suddenly became textualists and did not want to look at the legislative history. What is disturbing about this case is that the justice voted unanimously and found that those who buy debt and collect them for their own business and not third-party debt collectors. They're not? But the law was passed to protect consumers against abusive practices in collecting debts. And to take only part of the law without looking at the congressional intent suggests that the court is doing nothing. It's not doing its job. The issue before the court, the Supreme Court, was whether the Fair Debt Collections Act applied to Santana Consumer. And it was revolved around the act applies to a debt collector. The act includes a definition of a debt collector. The term debt collector means any person who uses any method of interstate commerce or the mail in any business, the principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect, directly or indirectly, debts owed or due, or asserted to be owed or due. The question was whether Sanders Consumer fit into this definition. In this case, all of the justices agreed with the decision. It appears that rather than look at the legislative intent of the law, the court wants the legislative bodies to once again clarify the law. It might require that the legislature just say that the Fair Debt Collections Act can be applied to any business that collects debts in an abusive manner. Doesn't make a difference if it's a third party or whether they're a debt collector who bought the debt. I have a feeling that the legal profession is very much involved in this, buying up billions of dollars of debt for pennies on the dollar, and then go after people because they can handle illegal work without any costs. In any case, Justice Gorsuch, writing for a unanimous court, said, "We begin as we must with a careful examination of the statutory text. The court found the answer to the question presented in the plain meaning of the law." Justice Gorsuch said, "And by its plain terms, this language seems to focus our attention on third-party collection agents working for a debt owner, not on a debt owner seeking to collect debts for itself." In other words, if you own the debt, you can abuse consumers, but can't be brought to court under the Fair Debt Collections Act. It's only if you're a debt collector for someone who owns the debt that the law applies. It makes no sense whatsoever, and you have to wonder what the court is up to. It was interesting reading because I summarized significantly, but if you read the actual laws and the court decision, you say, what are these guys talking about? The law was made to protect consumers and not to abuse them or allow others to abuse them. Of course, it's meant for anyone who tries to collect a debt, not just third-party debt collectors. Okay, that's our lesson for today, and the question is, do we need more intelligent people in the Senate and the House of Representatives? Because if they wrote this clearly, then this issue would not have come up before the Supreme Court. And that's about it. Peter, come here.
Don't you think the question is, besides we need more intelligent people in Congress, we need more intelligent people in the Supreme Court?
Someone raised the issue whether we need more intelligent people in Congress or more intelligent people on the Supreme Court.
Or maybe both?
Possibly both. I can't understand how the justices in one decision can vote 5-3. We had 3 dissents, and in the other one it's unanimous court. It was 9-0. It makes no sense, and one has to wonder why those who dissented in the bankruptcy action didn't dissent here, because effectively the case involves screwing consumers. Okay, have a good day. The conclusion in this article is relatively simple. In the 2 cases that were brought before the Supreme Court, the court interpreted the Fair Debt Collection Procedures Act, a statute that's meant to protect consumers, in a way that strongly favors creditors, under the guise of just following the plain meaning of the statute. These cases are typical of what usually happens in cases where the court says it will interpret laws based on their plain meaning. Pretending plain meaning provides answers when it doesn't, obscures the real basis for the decisions, and keeps the court from focusing on fulfilling the legislative purposes in enacting a law. In other words, the court isn't following the legislature by using plain meaning rather than combining the statute with the legislative intent, which usually is when the legislature debates and raises issues, or for that matter when the law is consolidated between the 2 houses, the Senate and House of Representatives. This is the end of today's section.